Good morning. It is 9 a.m. on Friday, February 6, 2026. We're here on two matters in case number 26-90103, Sachs Global Enterprises. So two things. One, please mute your lines when you're not speaking so I don't have to activate the hand-raising feature. Second, everyone make sure to go to my webpage and note your appearance because that's the way we to keep track of formal appearances in the case. So I'll start with counsel in the courtroom, and then I'll go to counsel online.
Good morning, Your Honor. Kelly Norfleet from Haynes & Boone on behalf of the Global Debtors.
Good morning.
Good morning, Your Honor. Jared Martin from Bradley Aaron for the SO5 Digital Debtors. Also joining me in the courtroom is my colleague, Michael.
Good morning.
Good morning, Your Honor. Kathy Patrick at Gibbs & Bruns. I'm counsel for the plaintiffs in the interchange litigation that are here on the motion to seal.
Good morning.
Good morning, Your Honor. Howard for the U.S. Trustee.
Good morning. All right, let's start. Mr. Einstein.
Hello, Your Honor. Matt Eisenstein from Arnold & Porter on behalf of Visa, Inc.
All right, Mr. Michael.
Good morning, Your Honor. William Michael for non-party MasterCard. MasterCard is a defendant in the interchange litigation, and I'm here for limited purpose of addressing any questions the court may have in connection with the debtor's motion to seal.
All right. Ms. Spiegel.
Good morning, Your Honor. Robin Spiegel, Wilkie, Farr & Gallagher, counsel for the debtors. Mr. Ward is also with Wilkie. He's going to be presenting. I actually appeared because his camera wasn't working. All right. So I'm going to go off camera. Thank you.
All right, thank you. Mr. Manal.
Good morning, Your Honor. Doug Manal from Morrison & Forster, proposed counsel to the Official Committee of Unsecured Creditors.
All right. Ms. Bors.
Good morning, Your Honor. Alicia Bros from Boris, Taters, Seymour, and Pease on behalf of the plaintiffs, Sachs, and the underlying interchange litigation.
All right. Mr. Hopkins.
Good morning, Your Honor. Christopher Hopkins of Paul Weiss for the ad hoc group of bondholders and dip lenders.
Mr. Ward.
Good morning, Your Honor. Nathaniel Ward from Wilkie, Farr & Gallagher on behalf of the debtors.
All right. Mr. Castleman. Mr. Castleman, I don't have anyone muted.
Oh, okay. Sorry, Your Honor. In case. David Castleman from Augsburg on behalf of Bank of America as ABL agent.
All right. Why don't we take up the interim cash collateral first?
Thank you, Your Honor. Jared Martin again for the SO5 Digital Debtors. We resolved all objections to the third interim order. We filed a red line at docket number 694-2. 694-1 is the order we'd like you to sign. And just as a matter of course, we moved to admit exhibits 1 and 2 at docket number 695, which is the first day declaration of Mr. Hebe and the amended approved budget. The primary changes were to release the funds in escrow to the global debtors, which amount to approximately $700,000, and then to increase the escrow from $5 to $350 on a go-forward basis. And then we'd ask to set the final hearing contemporaneous with the other secondary hearings in the jointly administered cases, which I believe is going to be February 20.
Right.
But to the extent that date changes, just have it match with those dates.
All right. All right. That's fine. Does anyone else wish to be heard with respect to the third interim cash collateral order for the digital debtors?
Your Honor, if I could briefly,
yes.
And if I could ask, it was very difficult to hear the counsel speaking. I don't know if people are not on mute, but I would like to just spend a little bit of time, Your Honor. This is the first opportunity to appear before you in this matter, and maybe perhaps say a few things to introduce the Unsecured Creditors Committee, and then remark on the cash collateral order.
Sure, go ahead, Mr.
Okay. Thank you, Your Honor. Since its appointment on January 27th, the Unsecured Creditors Committee has engaged my firm as well as The Cole Shops firm as local counsel, Alex Partners as financial advisor, and Houlihan Lokey as an investment banker. And Your Honor, you may be aware that the committee is comprised of 11 members. It makes up some of the debtors' largest vendors, including luxury brands Chanel, LVMH, Zegna, Kering, and Rosenex, as well as the debtors' major landlord, GGP, the Union, PBGC, as well as Amazon and Computershare, and finally the service provider, Keller Mayer. In other words, Your Honor, the committee is representative of the lifeblood of this business. It has representatives from the vendors, from labor, and from real estate. It's been an extremely busy week, Your Honor, and the committee members have been fully engaged, and we truly appreciate their efforts here. We are getting up to speed. We have reviewed some financial information from the debtors. We expect more. We've had numerous calls, both with the debtors as well as the lenders' professionals. And we are actively engaged with them regarding the debtor in possession financing and the second-day relief, and we very much appreciate the brief adjournment to hopefully get us on the same page before the second-day hearing. In addition, Your Honor, we've had an in-person meeting very early, since we were just appointed recently, Your Honor, with management and members of the committee. And we look forward to continuing the discussion between the principals regarding partnering with the debtors on a business plan going forward. But, Your Honor, what is front and center today on everyone's mind and is a particular focus for the Unsecured Creditors Committee is the need to repair the debtors' relationships with the brands and the vendors, and without whom there simply is no business. Your Honor, the debtors have made significant progress in their efforts, and they have obtained significant debtor in possession financing, and you have awarded them authority to make those payments that are critical to the debtor's success. And Your Honor, that money needs to start going out the door immediately. And we are hopeful that the debtors understand this, got the message, and we are optimistic, Your Honor, that when we get back before you in a few weeks, we'll be able to report back that those payments have actually been made. We look forward to continuing our efforts to find common ground, both with the debtors and the ad hoc group, and to avoid a contested second-day hearing. But, of course, we're not shy. We'll let the court know if issues arise. With respect to the issue of the cash collateral order, Your Honor, the committee has no objection to the interim order being sought. A lot of the committee's issues have been preserved for the final hearing, and we'll be back before Your Honor if we can't work things out with the debtors and the lenders on this.
All right. All right. Anyone else wish to be heard? All right. Obviously, I've reviewed the first, the second, and now the third interim order, and in connection with the digital debtors and what they're trying to accomplish, I think the proper exercise of the business judgment preserves the issue of the intercompany relationship, and there is a payment being made. So I'm going to go ahead and approve that order. And I'm going to mute the lines, so hit 5* if you want to be heard. Thank you. There's just a lot of people on and a lot of background noise.
Conference muted.
All right, that order has been signed and sent to docketing.
Thank you, Your Honor. One housekeeping item. I understand that the second-day hearing has been or will be adjourned to the 20th. I think we would like to keep the 13th for the final hearing on the liquidation motion, just based on the pace of the liquidation of the assets on the website. I think pushing that one to the 20th puts it a little bit further into the timeline for the liquidation. I think for all parties in interest, it should still go forward on the 13th. And we'll be in touch with Mr. Laws about that.
All right, and just make sure you coordinate with the committee
of course.
On that. And we do obviously have time on the 13th. It would be The 13th would be a virtual hearing.
Of course.
And the 20th will be a virtual hearing. Both of them would be.
Thank you.
All right, thank you. All right, I've unmuted a 646 number. Is that you, Mr. Ward?
Yes. Yes, Your Honor. 646-248 is mine. Doug Mantle. Sorry, Your Honor.
Yeah, got it. Okay. And Mr. Ward, are you 212-905 number? No. All right. I've unmuted someone at 212-905. Just hit 5* one time, and I will unmute your line.
Your Honor, David Castro from Waterbury. I'm the 212-905 number, but that was just to make the appearance.
Got it. Okay.
Earlier.
Thank you. Mr. Ward, I can't. I don't see anyone showing up. Can you hit just 5* one time on your phone? If you hit it the second time, it lowers your hand. No. Are you? Can you say something? No. No, I can't hear you. 5*.
Conference unmuted.
All right.
I think I just got unmuted, Your Honor.
Yeah, no, I unmuted everybody. Go ahead.
Oh, great. It was doing hand raised, hand lowered, but I'll proceed. Are we ready to proceed then, Your Honor, with
Yes.
the motion to seal?
Yes.
Great. Okay, well, thank you, Your Honor. For the record, again, Nathaniel Ward from Wilkie Farr and Gallagher, representing the global debtors. Your Honor, we're here on the debtors' emergency motion to seal, which is docket number 641, filed in connection with our Rule 9019 motion seeking approval of settlements arising from the underlying litigation related to interchange fees charged by Visa and MasterCard. For the record, the sealed version of the 9019 settlement motion is at docket number 637, and the redacted version is at 642.
Yeah, and let me just, before you go on, so under our local rules, the way that the motions to seal work is you can file a motion to seal, and it will be heard on 21 days notice. And it's automatically granted for that 21 days. The purpose for the hearing today is to unseal it as to some people while that 21 days runs, because at the end of the day, we're going to need to have, if there's an objection to the sealing after 21 days, we'll have a hearing on that as well. So the relief today that I'm considering is just really limited to your ability to provide the committee, subject to whatever confidentiality agreements may exist in a case that was filed, I believe, in 2014, allowing to do that. So that's the limited relief I'm considering today, which is what I understood your order to be asking for.
Correct. Yes, that's exactly right. So, Your Honor, I think it's worth just at the outset recognizing that this probably gets to what you're saying, but it is a bit of an unusual motion in a few respects. First, it's unusual in that the information that the debtors seek to seal and permit some limited disclosures of, as you mentioned, is extraordinarily sensitive. It relates to settlements that arise from the multi-district litigation involving interchange fees, involving claims by millions of merchants, and disclosure of that information could directly affect Visa and MasterCard's ongoing negotiations with other participants in that litigation. Second, the confidential information that we're seeking to redact and do the limited disclosure of, it doesn't belong to the debtors. It belongs to Visa and MasterCard. And as a result, the debtors can't choose to disclose that confidential information without risking a violation of the underlying protective order in the interchange litigation or of the terms of the settlement agreements and the other agreements themselves. And then last is exactly what you hit on, Your Honor, is that because we can't disclose those terms to the parties in interest for the 1919 settlement motion or we can't do that until we have an order of the court, we risk sort of a procedural hiccup where we end up with 42 days of notice, or 42 days before we can really have a hearing on the 1919 settlement motion. Your Honor, it sounds like you're obviously very up to speed on all of this, and I have argument I can walk through, but it may make more sense if you have specific questions or things that you'd like me to address.
No, just two concerns. I just want to make sure that nothing that I do invades the province of the court in the underlying litigation. That's number one. And then number two, I'd like to hear from people. I understand this is really a practical issue that needs to be resolved in order for the debtor to be able to proceed with the settlements. And obviously the settlements have to be evaluated on their merits. And at a minimum, I think that, the committee is entitled to know exactly what the settlement is. They're in a state fiduciary. And I'm not sure that the members of the committee have to know, but certainly committee counsel and committee professionals likely need to know. So we've got a practical problem, and my question is, how can we best solve it?
Great. Yeah, and I think on the first question, from our perspective, and it may be helpful also to hear from counsel from Visa or MasterCard, but from our perspective, if we're able to obtain the relief we seek in the motion, then we're not going to have any comedy concerns or inconsistent rulings, that sort of thing with the court in the underlying litigation. And then on the practical concern too, I think what we're approaching here, what we're trying to do here is to navigate the balance between observing the confidentiality requirements and the protective order in the underlying litigation, and at the same time make the level of disclosures we need to in order to have a full and fair hearing on the 1919 motion. We're asking, as you know from the order, that counsel to the committee itself get access subject to confidentiality agreements and requirements, obviously the U.S. trustee as well. It's our position that individual members of the committee, given the nature of the underlying litigation, it just really wouldn't make sense for the individual members of the committee to get access to this highly sensitive information, frankly related to litigation that some of them have themselves participated in. So I think that's how I would probably answer those two questions.
All right. Who else wishes to be heard with respect to this? Patrick.
Your Honor, I would, Kathy Patrick, we're plaintiff's counsel in the underlying litigation. I would simply echo some of what Mr. Ward said, but give you a little bit of color, particularly as it pertains to the consideration for the settlement, which is monetary and non-monetary. That is highly sensitive information, not just for Visa and MasterCard, but in my view, for the debtors themselves. The rates they pay to accept Visa and MasterCard payment cards are competitive information for them. You should know that we treat this so sensitively that none of our other clients, all of whom have now settled their claims, knows the rates that the other clients got in the settlement. We were assiduous in keeping that separate because it was so sensitive and because they are also competitors. And so there is a reason why, and as long as the committee is willing to accept it on a professional's eyes only basis, we don't have an issue. But there are merchants on the committee, and that's the sensitivity. And I know that Mr. Eisenstein and Mr. William would have the same, Bill Michael would have the same concern for Visa and MasterCard.
All right, thank you.
Thank you.
All right, anyone else? Mr. Winnie.
Thank you, Your Honor. I did have a chance to take a look at the sealing motion, and I also looked at the redaction. I know today is not the day, but we do have some problems with it. In the motion it says that the sealing is narrowly tailored to protect the sensitive information that are on the settlement, but the entire sheet is redacted. And this is an asset of the state, and there is a public interest in terms of inspections and copy of judicial records that we need to balance. But to provide to us and the committee, that's a significant step in disclosure. But there's also a balance, and in a case where there's press, there are customers, there are thousands of creditors from the state. They should have access to the information. I'm not saying go out and disclose the rates that the debtors are paying, but at the very least, we need to know what the assets are. We need to know how much of the money is coming in. So in terms of the redaction, I think there's a way we can work it out instead of redacting the whole term sheet. So in the next 21 days, I hope to work with the debtors and the plaintiffs to come up with some sort of solution that balances the disclosure required under both Section 107 and the common law interest, the common law right of the public to access judicial records. That's under the Supreme Court case Nixon. So I'm hoping to have this resolved. I don't want to fight this, but
yeah, but I'm mindful of the fact that we're already dealing with a confidentiality order that has been in place since 2015 in another case. So I don't want to do anything that would in any way run afoul of that order.
That's correct, Your Honor. And I've seen some of those. I've tried looking it up. I mean, there was like 2 cases cited within, so I was trying to look for that confidentiality order.
It's attached to the exhibits.
Okay. I will take a look at it, but thank you, Your Honor.
Well, yeah, they usually like you to do it and date them the very day of the loan closing.
All right. Can everyone please mute their line? Mute your lines. We're getting a lot of background noise. All right. Who else wishes to be heard?
Thank you, Your Honor. Jared Martin for the SO5 digital debtors. I just wanted to note for the court that the digital debtors are also parties to the 9019 motion and the motion to seal. This settlement is material to our estates, and we are very much in favor of the sealing motion. Wanted to flag one thing. We'll work with the committee and our lenders on this issue, but to the extent that our cash collateral budget contemplates settlement proceeds, we'll work to either redact that or find some workaround so that that is also complying with the protective order and the sealing motion.
Understood. Thank you.
Thank you.
All right. Who else wishes to be heard?
Your Honor, Doug Mantle, proposed counsel for the Unsecured Creditors Committee. 2 things, Your Honor. First, briefly, the proposed order talks about counsel having access, and I would ask that that be revised to have all professionals. I became a lawyer because I'm not very good at math, so I would really appreciate being able to share it with my financial advisors. And the second thing is we just haven't had time to fully discuss this with the members of the committee, so we reserve all of our rights to the final hearing if one is necessary with respect to this matter. But appreciate the debtors' efforts here.
All right. Anyone else? All right, Mr. Ward, I've reviewed I've reviewed the motion. I think this is a good solution to address a practical problem that has significant commercial implications. And I'm prepared to enter the order. And you all, do you want to discuss with Mr. Mantle the all professionals, or should I just interline that in the order? It's that.
Your Honor, if I could just be heard on the professionals issue.
Yeah.
This is just an odd feature of this case. As in many bankruptcy matters, there are people who are investing in claims or proceeds of claims. We would need a representation from the committee's professionals that they would have an ethical wall between whoever. I don't even know who their professionals are.
Houlihan and Alex.
Okay. That they would just not be advising anybody on the purchase of claims or investment in claim proceeds, because that then blurs the line and creates that issue. Assuming we can have that modification We have worked that out with the ad hoc lenders advisor, Lazard. They made that the representation. It's just fine. I just wanted to flag that.
All right, all right. So, Mr. Manel, can you work with Mr. Ward just to make sure we have that? I don't know, it has to be in the order, but it can just be a representation.
I'm happy to work with Mr. Ward as well as Ms. Patrick. Absolutely, Your Honor.
And Your Honor, if I may, William Michael from MasterCard.
Yes, sir.
That is fine. MasterCard does not object to the financial advisors having access subject to the limitation outlined by Ms. Patrick. I would just add that that would, from our perspective, also need to be subject to an undertaking to be bound by the protective order in the underlying litigation.
Okay. All right, understood. All right, so I'm going to grant the motion, Mr. Ward, and would you please just work with Mr. Manel and the others to see if the language in the order addresses it, or if we need to have a change to the order. And then once that gets done, just have someone contact my chambers, and I'll get that order entered as soon as possible. You know, I would hope that by Monday this is all cleared up, so the committee has a couple of weeks to look at this.
Just one question. I'm just a little bit confused about the committee itself and what sort of confidentiality obligations we're considering having them sign up to.
No,
we weren't anticipating them.
Yeah, the committee. The committee. We're talking only about Alex Houlihan and counsel. All right, and you know, you need to address Mr. Michaels. Miss Patrick's concern was that Houlihan and Alex, and presumably the lawyers, would not be advising anyone on claims purchasing with respect to this, which I think is reasonable, and frankly, I wouldn't have thought that a financial advisor to the company would be advising that another branch, arm of it, would be advising, you know, trading in claims in the company, but that's a different issue. So I think that the concern is that we don't want to do something that runs afoul of the, you know, confidentiality order, the protective order in the underlying case. So I think this is all, in my mind, plumbing, just to make sure that we have it all correct. I don't think it's a substantive issue, and I agree that, you know, this, hopefully we'll get this resolved today, and I'll enter the order, and Monday the information will be able to be shared.
Okay, I think that sounds good. We'll make sure that we're not going to be contrary to the existing underlying agreements. But so that Visa and MasterCard have an opportunity to object to this if they want to. I don't think that the counsel representing the committee would be actually signing the underlying protective order. They would be bound by their existing confidentiality obligations, not signing up to some additional order.
All right, I'll Ms. Patrick.
Your Honor, what we have done in the past is people have agreed. I apologize.
Yeah.
I should just stay up here. What we have done with prior professionals and firms is the firms and their advisors have given an undertaking to abide by the restrictions. They don't sign the protective order. Nobody does. It's Judge Brody's order.
Right, exactly.
Okay.
Yep. Yeah, it's just we'll abide by those terms. Yeah. All right.
Okay. Yeah, as long as if the committee is good with that, then I think we're good. Thank you, Judge.
I don't think anyone has a choice. That there's an order out there that governs this already before I ever came on the scene. So.
Your Honor, in fairness, I have not seen the protective order. I presume that it should be fine, but we'll come back to the court if there's any other issues.
And I think it's attached. So the actual order itself is a minute entry. There is a long stipulation and a letter in a letter like the practice in New York where you send a letter and attach it, and then that's, I think, at docket
277.
Yeah.
277 in the MDL case.
Okay. And then there's a two-sentence docket entry that says the order is approved. So it's not a signed order. It's
so ordered on the docket.
It's ordered on the docket. So you have to look at both of those, and they are at.
Judge, I think it's attached to our exhibit list.
Yeah, that's what I'm looking for.
680, Your Honor.
Yeah, 680-1. Yes, it's
681.
It's 680-1 is the letter with the protective order submitted, and then 680-2 is the minute entry where the judge approves that letter. So in our docket, 680-1 and 680-2.
Okay, Your Honor, we'll follow up with Mr. Ward and Ms. Patrick.
All right. Thank you so much. All right. Thank you, Ms. Patrick.
May I be excused?
Yes, ma'am. All right. Anything further today? All right. We'll be in recess to my 10 o'clock.